We've read a lot of articles in the news about the Attorney General's foreclosure settlement with the major banks and servicers. We've read all we can about that settlement, although we haven't been able to see the entire agreement because that consent decree, to our knowledge, has not been filed in court yet. But we have some concerns about the settlement from a consumer and borrower standpoint and from the standpoint of private consumer lawyers. The first major concern is that the settlement was entered into from what appears to be a situation where there was no full investigation done. Now, the U.S. government and the 50 state attorney generals have an incredible amount of subpoena power and could have done a very detailed and thorough investigation of all of the wrongful foreclosures and the robo-signing instances throughout the country. We'll never know what really happened behind the scenes until that full investigation is done. Now, the second issue is we're concerned that borrowers are not going to get enough relief under the settlement. There's talk of big numbers, billions of dollars in the settlement, but how does that translate and get down to borrowers? If we look at the loan modifications promised in the settlement, we've seen all that before. The federal government ran a loan modification program which was terrible. It was a dismal failure. So we don't want to see more of that again for these same borrowers. Second, the issues of refinancing. Well, that's kind of a bit like a coupon settlement. You're going back to the mortgage industry and basically buying more services from them. And there's a big concern of whether people are going to have the credit to really qualify for those refinancings. And now the principal reduction, that's a little too late. The principal reductions for many folks should have came a long, long time ago. And we don't understand how a principal reduction helps someone pay the current amount on their mortgage. Now the issue regarding the wrongful foreclosures where they'll receive up to $2,000. I don't know how that relief is adequate for anyone. If you're like the folks we know in Michigan and Arizona, who their homes were wrongfully foreclosed on, their families were kicked out of those homes, had to move somewhere else, and then the bank reveals, oh, sorry, it's a mulligan here, we're just going to take it back and give you your house back. Well, that's a problem. You're going to give those folks $2,000 for being kicked out of the house and losing their home. We don't see how under any circumstances $2,000 for a wrongful foreclosure is anywhere near adequate. A fund should be set up and there should be a damage matrix like in mass tort settlements where folks can prove their claims and get paid out of a fund rather than just $2,000. Now lastly, the servicing standards announced in the settlement, although we haven't read them all, we have concerns about those servicing standards. What it appears from first blush is that the servicers are now going to have to comply with the law. Well, they had a requirement to do that all along. And without regulation in effect, rather than a consent decree, which expires in a certain period of time, without regulation and better yet legislation, we don't see how in the future the servicing industry is not going to fall back into the same patterns we've been seeing all along. So we hope those concerns for borrowers are somehow resolved in the settlement, but we'll see how it plays out over the following months and years as the settlement is implemented.